President Trump made a number of extravagant promises on his way into the presidency, one of which was a mass deportation campaign of illegal immigrants. Shock and awe were the watchwords for how big and how fast this effort was going to be. And yet, while Trump has made more big impact on the US immigration system in his first 100 days than probably anyone else, he is not meeting mass deportation aims, largely because his actions keep failing in the courts. So in this video, supported by the Patreon members of this channel, let's have a look at what's going on. Now, in principle, there's nothing unique or terrible about the idea of an administration actively deporting people who entered the country without permission. According to the Migration Policy Institute, more than 12 million people were deported during the Clinton administration, for instance, and more than 10 million during the George W. Bush admin. Obama was responsible for under 5 million, which his team said the lower numbers reflected that he prioritised those convicted of serious crimes and recent arrivals, which you can see in this graph with the uptick in border removals and the downdrift of interior removals. Obviously a somewhat different story under Biden, distorted as it was by Title 42 expulsions at the border due to the COVID-19 situation. More people were repulsed at the border, but many tried multiple times and specific numbers are not reliable. There was obviously a surge in attempted crossings associated with messages received about the chances of success under the Biden administration. But now Trump wants to draw a line, and he's going to use shock and awe to do it. And that's certainly done a lot to successfully shut down the border. But he's failing so far in his mass deportation efforts, and that is because there are hundreds of lawsuits that are pushing back against his actions, and often successfully. The success comes because of the norm-breaking shortcuts the administration has been taking as it tries out a maximalist expansionist view of its own power. And it's been showing total disinterest at best, downright contempt at worst, for ideas such as fairness and due process. The administration has been quick to complain about radical leftist judges, but the truth is that judges appointed by both parties have been involved in blocking certain moves. The most important of these, arguably, has been the pushback against one of the administration's earliest and most audacious innovations. On day one, President Trump announced several emergencies. One of those was that there is an emergency at the southern border, but that simply set the tone for his then subsequent invocation of the Alien Enemies Act, alleging that this was needed to deal with what was described as an invasion of the United States by the Tren de Aragua gang from Venezuela. The various emergencies were all obviously bogus, invoked purely for the purpose of giving license to the president to take direct executive actions that would not normally be within his power. And so it was in this case. It gave the excuse to seize people deemed to belong to the invading group, secure and remove them with relatively few safeguards. The act is intended for use during the actual invasion of a country by a hostile army, not for dealing with illegal immigrants, however objectionable and detrimental you may decide that they are. It has only been used 3 times before, in the War of 1812 and the 2 World Wars. After the last time it was used by Roosevelt in World War II, it was very much held to have been a stain on the nation's honour how it had been used in that case, and it fell into disrepute. Not a problem for President Trump, who wanted to use it to its fullest extent to export as many people as possible. That was blocked just a couple of days ago by US District Judge Fernando Rodriguez, a Trump-appointed federal judge. The judge pointed out what even a legal numpty like me would have presumed, that the act could only be invoked in an actual time of war or invasion, an armed, organised attack. You'll recall that it was in using the special powers supposedly available under the Act that Trump deported plane loads of alleged gang members to the El Salvadoran gulag known as Chicot. So this wasn't about deportation, it was about imprisonment in circumstances so brutal that they would have been illegal on the territory of the United States, and it involved no due process. So it's not as though any of the individuals concerned were even given the chance to show that they weren't gang members. The administration suggested that it was beyond the purview of the courts to oversee the president's use of the Act, which would be a nice get-out-of-jail-free clause if it had held. But the judge in this case was having none of it. He said this: allowing the president to unilaterally define the conditions when he may invoke the AEA and then summarily declare that those conditions exist would remove all limitations to the executive branch's authority under the AEA. Yeah, I kind of think that was the whole point. Also in the courts, the Trump administration attempts to export people to countries other than the person's country of origin. That has also been challenged. So with some cases, people have fled their own countries because they wouldn't be safe there, and they're allowed to stay in the US because a court looks at their situation and agrees. So then places a ruling forbidding them to be deported to that country. The administration simply tried to get around this by deporting such people to third-party countries without even necessarily telling the people which country they were being taken to. Again, no due process. That has now been blocked by a federal judge in Massachusetts. The case is being appealed. Also in the courts, the Trump administration had sought to cancel en masse the legal status of hundreds of thousands of people who had been granted authorization to live in the United States, people who had been fleeing 4 countries: Cuba, Haiti, Nicaragua, and Venezuela. They had had extensions to previous authorizations to remain, but the Department of Homeland Security had simply rescinded those extensions. 2 judges, California and Massachusetts, blocked that action, preventing the imminent departure of the people concerned. That now is subject to an emergency appeal to the Supreme Court. Obviously, the one single case that has been attracting all the attention has been that of Kilmar Abrego Garcia, the man who was accidentally deported to the exact country where there was a prohibition from sending him to. Not only that, but because the administration believed him to be a gang member, with evidence originally considered to be too thin to rely on by the department's lawyers before the White House got directly involved, he was sent to the El Salvador gulag aforementioned. I keep calling it a gulag because let's not call this a mere prison. Again, the reason why they are sent to a place on foreign soil is because these are not conditions that would be legal in the United States because they are unnaturally cruel. Because look, I agree with some people that some human rights lawyers and institutions have engaged in overreach, but we do still believe in basic human rights, yes? I mean, we do, don't we? If you're deporting someone to their own country when they illegally entered, that's one thing. Relatively light process is appropriate to confirm the justice of the case there. But if you're sending someone to that hellhole who has no criminal record, all you're going on is that he has tattoos, it's an astonishing betrayal of any sense of fairness. All the discussion since then has been about whether Garcia is a good person or not, indeed whether he actually might indeed be a gang member or not. None of it, of course, is the point. You need the standard high quality of proof before you send anyone to a prison. And frankly, no standard of proof should be high enough to justify sending people knowingly to a place such as this. Other cases have included college students and academic researchers who the administration has tried to deport because they took part in protests to speak out against Israel and/or in support of Palestinians. They were attemptedly exported because Secretary of State Marco Rubio drew on a provision of immigration law that can be invoked if the presence of someone in the United States harms American foreign policy interests. But wait, you might say, wasn't this the United States of America, where the principle of free speech is held to be sacrosanct by the First Amendment to the Constitution? Yeah, but as I said before, historically free speech is held to be crucially important by politicians when they're in opposition, less so when they're in government. The administration claimed that such rights do not belong to student activists in the US on a visa. Well, that argument was denied by US District Judge William Young, a Reagan appointee. He wrote this in his long decision on the case. Although case law defining the scope of non-citizens' First Amendment rights is notably sparse, the plaintiffs have at least plausibly alleged that non-citizens, including lawful permanent residents, are being targeted specifically for exercising their right to political speech. But where, you might wonder, are all those MAGA activists who love free speech so much? Like the ones alleging that, people in the United Kingdom are all getting locked up for posting innocent memes on social media that definitely are not inciting violence during riots or anything like that. Well, some of them, including Elon Musk, are to be found calling for those judges to be impeached. But then Elon Musk's maximal free speech platform Twitter has been found to downgrade the reach of people who he has arguments with or to cancel their verification. So let's not pretend that there's the slightest interest in consistency or principle in any of this. Now, another case, a California judge, Jennifer Thurston, ruled that the Border Patrol was overreaching its legal authority by carrying out arrests and stops of suspected immigrants without a warrant. There is a requirement that they should have grounds for reasonable suspicion that someone they stop is in the country illegally, which they weren't remotely even pretending was the case. That order prompted the President's Deputy Chief of Staff, Stephen Miller, to go off on something of a rant on Fox News. He said this is the choice facing every American. Either we all side and get behind President Trump to remove these terrorists, more accurately described as alleged terrorists, that whole boring innocent till found guilty thing, from our communities, or we let a rogue, radical left judiciary shut down the machinery of our national security apparatus. The other demonstrable overreach by the administration is Trump's attempt to redefine birthright citizenship, abolishing it for certain non-citizen parents. According to the Constitution, there is a guarantee of citizenship to all those who are born on US soil. Now look, you can think that's a good idea, you can think that's a bad idea. Personally, coming from a country where it's not the case, I certainly am not going to project any opinions on the principle. But if it's in the Constitution, then the only accepted way to change that is, of course, to amend the Constitution, which obviously is a tricky thing to do by intent. So 3 district judges very quickly rejected Trump's order. The case that they should have the power to block a federal policy nationwide rather than simply within their own state. That specific element is making its way to the Supreme Court, a fairly limited case on the power of state courts to place injunctions across the whole country. Presumably, the actual substance of the case itself, whether or not it's constitutional for the president to do what he's doing, that itself will end up at the Supreme Court as well in due course. Now, Stephen Miller also had something to say on this subject. Guess what? Yes, indeed, that birthright citizenship presented a threat to national security. He said this: "It has been used by foreign governments to conduct espionage against the United States." That's a pretty specific and substantial claim, so presumably you might think there's some pretty solid evidence backing it up. Nope, the word of the great leader should be all you need. Not all the cases that have seen the courts fighting back have been related to immigration, of course. For example, just yesterday, a federal judge ruled that one of Trump's executive orders targeting a named law firm, in this case Perkins Coie, was unconstitutional. Now, that's the first time a court has permanently barred Trump from trying to punish a named law firm that he feels has opposed him in some way or another. It's related to the immigration cases in one sense. It was about the administration deciding that it had the authority to go after certain groups of people, to act against them outside of the bounds of existing processes. A couple of pieces, one in New York Times, one in The Atlantic, have talked in the last few days about how emerging authoritarian regimes often establish a two-tier legal system in precisely the way that Trump seems to be attempting. This refers to the dual state theory put forward by German lawyer Ernst Fraenkel in the 1930s. It suggested that authoritarianism can take hold in small pockets, so that the broader legal system appears to function more or less normally for the majority of people, but then there's a part that the government directly controls which has no rules, a legal abyss into which some people may fall and never get out of. Frankel's contention was that in that situation, authoritarianism arrives earlier for some people than it does for others, those belonging to groups targeted by the state, the weak and the vulnerable. Those people find themselves early on subjected to state violence without prohibition, and mostly the rest of society just carries on, supported as normal by the rule of law as it applies to them, so they don't much notice, or dare I say care, about those on the wrong end. But of course, once you've established such a legal abyss, over time, it can grow more powerful and far-reaching until it can become the societal norm. As well as Frankel's own 1930s Germany, similar situations apply to early apartheid rule in South Africa, the military dictatorship of General Pinochet in Chile. Arguably it exists today in China with a fully formed and functional legal system, but a wholly separate legal abyss for political dissidents, Uyghurs, and even tennis players like Peng Shuai, who made public the misdoings of a powerful figure. And of course it certainly exists in Russia. A normal judicial system exists, but it's not to be confused with the one that Alexei Navalny ended up in, where the conclusion was foregone from the second he stepped into the courtroom. Another example, interestingly, would be El Salvador, the location of the previously mentioned Gulag, housing deportees from the United States. One legal system for the majority of citizens, a wholly different and arbitrary system for the targets of President Bukele's crackdown against suspected gang members. Right now, all the court cases I've cantered through in this video, they reflect the furious fight back by American courts to prevent the creation of such a legal abyss. It would be unprecedented for an American president to be able to bypass due process, to punitively go after certain groups of people, careless as to the truth of whether they had committed any crime or not. But when President Trump said that only he and the Attorney General are the sole authoritative interpreters of federal law, that is exactly the destination where that leads. So this is the test. It is possible for an authoritarian-minded president, surrounded by compliant agents in every cabinet post, to create the dual state in the United States of America. If the courts fight back against this and ultimately fail, then it would probably be the end of the most important guardrail that remains against it, perhaps alongside having the process of free and fair elections. Something to bear in mind when administration figures are railing against activist judges and terrible journalists who keep asking questions about whether they're going to obey the legal rulings of the courts. My thanks to those who support this channel on Patreon. Without them, these videos would not be possible. If you think you would like to join them, please head on over to patreon.com/Mallen Baker. It is always appreciated.